Hi, everyone, and welcome to the webinar Know Your Rights, Intellectual Property Considerations for the Emerging Designer and Freelancer. This event is organized by the Design Singapore Council in partnership with Ella Cheong LLC and is supported by the National Design Centre. This event is also part of the National Design Centre's Next Gen program lineup for October to November this year. I am Felicia from the Design Singapore Council, and I will be your MC for today. Today's session will cover key IP considerations that emerging designers and freelancers should take note of, and will touch on important practical aspects like design registration, ownership, copyright issues, as well as licensing. The session will begin with a presentation by our partner Ella Cheong LLC, followed by a Q&A segment, and will close with a sharing by the Design Singapore Council on the various shared services that are available for design firms. And last but definitely not least, our attendees today will also get to enjoy a complimentary one-to-one preliminary consultation with Ella Cheong LLC's team of professionals. So more details on this will be shared at the end of the webinar, so do stick around if you'd like to make use of this very helpful resource. So without further ado, I'm very honored to introduce our presenting speaker, Mr. Marcus Chan. Marcus is a legal associate at Ella Cheong LLC, a leading specialist intellectual property law firm in Singapore and Asia. He assists in a variety of commercial and contentious work in relation to IP law and handles the trademark portfolios for both local and international clients, advising them on the IP filing strategies, prosecution, management, and also the enforcement of their IP. Marcus is familiar with domain name disputes and also has experience in legal areas under franchising, distributorship, data protection, as well as software licensing. It is now my pleasure to hand over the time to Marcus. Marcus, over to you, please.
Thank you, Felicia, for the kind introduction. Now, let me just share my screen. Okay, so I hope everyone can see my screen over here. Now, thank you everyone for tuning in today. As Felicia said, my name is Marcus. I'm from Ella Cheong LLC, and today we'll be sharing some tips, on how for certain IP considerations for the emerging designer and freelancer. Now, let me just give a brief introduction of our firm. Ella Cheong LLC is a boutique IP law firm based in Singapore, and we are well placed to assist our clients in their IP matters in jurisdictions such as ASEAN as well as Asia. Now, we have 3 offices around the world, and some of you may know that our founding partner, Ella Cheong, she was actually invited from Hong Kong to start the budding IP industry in Singapore. And back then, when ASEAN did not have a strong IP grounding, so she was quite a renowned IP lawyer, and she was invited to set up shop here. And since then, we have now expanded our reach into more than 100 jurisdictions. We have represented over 10,000 IP owners for their various matters, and as you can see, there are about 30,000 IP rights being managed today. So now, moving on to our presentation proper, we will first talk about what IP is and what counts as IP. As most of you might be aware, it is a term with increasing importance and influence in the world today, not just for businesses, but also for individuals, and in particular, individuals working in the creative industries like yourselves. After going through briefly some of the major types of IP, we shall narrow in on the regulations surrounding registered designs and copyright. Next, we will look at the relevant rules that may apply to the emerging designer and freelancer, as well as key IP considerations that may be important to you. Finally, I'll be sharing some recent updates that may apply to your work and some key takeaways and practical do's and don'ts for everyone. Now, what is intellectual property? Some of you may know this, but not everyone is actually aware. IP refers to intangible creations of the mind, such as inventions, literary or artistic works, designs, symbols, names, or even images used in commerce. Every one of us actually experiences IP when we go about our daily lives. For example, a trademark is a sign that you can use to distinguish your business's goods or services from those of others. They can identify the origin of the source of these goods or services. A patent is a right granted to an owner of an invention that prevents others from replicating that invention. And a person who owns a patent can use it, sell the invention, or even to import or export overseas. A trade secret or confidential information is some undisclosed information or a secret that is important to a business or company and is kept out of the public domain. Now, this can be very, very valuable for businesses. For example, you can have a recipe of a very popular dish or a drink, or even the special processes put in place by a company to ensure that its work is efficient. I will delve into the rules on designs and copyright later, as you will see. Now, first, at this juncture, you may be more familiar with what IP entails or covers, but you may wonder, is it really that important? And if so, why is it important? Now, first, we need to understand that IP or IA, intangible assets, is a tremendous growth engine for the modern economy. Traditionally, the best performing companies relied on tangible assets, and these assets will make up the bulk of the value of the business or the company. For example, companies with a lot of hardware assets, such as those in the manufacturing or construction lines. Not to say that hardware is no longer as important, but if you fast forward to today, you can see that 84% of the assets of the world's largest companies are actually grounded in IP or IA. It also shows you how, in a span of about 40 years, the focus in growth comes from a steady IA component. For example, a company that is very, very well grounded in IP or IA can hit its first $1 billion much faster now than, say, a company that has more of hardware assets. Now, to see how all these may apply to you, let's look at some of the design regulations in Singapore. The industrial design market is regulated and chiefly protected by the Registered Designs Act. We shall call it the Act. And first, what are the goals or reasons for the protection of designs in Singapore? Now, one obvious reason is precisely that designs contain eye appeal and the goal of attracting the customer's attention. This can be said to contain commercial advantage if somebody's design of a product is so successful that it should be protected from being taken advantage of by others in the market. Great designs provide great value. They attract customers, they build loyalty, and they help increase market share. Given the importance of design in today's world, it is important to understand how emerging designers and artists are very crucial in contributing to a Singaporean economy increasingly reliant on IP and IA as a key driver of growth. And indeed, Singapore's focus on design innovation as a method to boost the economy has been planned and discussed way back in the early 2000s, which I also believe led to the beginning of Design Singapore as it is today. Now, moving on to what it means to get a design registered in Singapore. Very generally, a design must satisfy two criteria. Firstly, it needs to be a design. It has to contain a feature of shape, configuration, color, pattern, or ornament applied to any article or non-physical product by any industrial process. The second component is that it must be new. But do note that what it means is it's not new in the sense that it's new in relation to eye appeal, but that it is not registered or published in Singapore or anywhere else in the world. So just a few examples of new designs can be, a new board game or a new electric scooter design or a new design of a toy. But do note that there are some exceptions, and these are probably too technical or contain information that is topic for another day. But you just need to know that there are certain exceptions to what is considered as a registrable design. Let me just go into an example. First one is the functionality exception. This is in relation to designs that contain features of shapes, for example, which are dictated solely by their function. Next, a design that is a must match exception. This is a design with a feature or shape that is dependent upon the appearance of another article. For example, if I have a design of a car, it is not likely that the design of the car door can be registered, because it is likely that the car door must match the design of the car. And next, the must fit exception. This is an exception for certain designs that, for obvious reasons, they must fit. So as such, they cannot be something that is registrable. And another example is an exhaust pipe of a car. Because of the space constraints and the requirements of an exhaust pipe, a design for an exhaust pipe is likely not registrable. Now, as you can see, these are some of the non-exhaustive requirements that one would need for a design registration in Singapore. As you can already see, it is not so straightforward. There are quite a lot of information that you need in order to get a design registered. And certainly, there are a lot of questions that are to be asked for each application. On top of that, you need to know that certain kinds of works are actually unregistrable as designs, or they are unable to be protected. Now, what do I mean? For example, there are specific types of works that are not allowed to be registered. These are unregistrable unregistrable works of art. For example, sculptures or printed matter, primarily of literary or artistic character. For example, calendars, certificates, greeting cards, labels, postcards, and even stamps. These, for various reasons, such as copyright, they are not able to come under the umbrella term of a registrable design. And we will explore later how they may be protected under copyright. Now, other examples of designs that cannot be protected are those that are contrary to public policy or morality and other types of artistic works, as we will see later. On top of getting your design registered, you need to know that registered designs, the protection is territorial. So just because I have my design protected in Singapore, it does not mean that I have a protection everywhere else in the world. This is especially for young designers nowadays who need to be aware that, with the increase in connectivity amongst the world today, and for products all over the world, you need to know that your end goal, your end product or article may be available overseas. So everyone needs to consider if they need to have an international registration for their design. On top of trying to get your design registered, both locally and internationally, you are also able to track what designs there are both in Singapore and other countries. So for example, I could do a search of the Singapore intellectual properties of Singapore officers database. They do have a database of some of the registered designs in Singapore and their information. And likewise, for those around the world, you could check out the search page at the World Intellectual Property Organization's website. Now, as I mentioned earlier, there are some types of works that may not be able to qualify as registrable designs. Why is this so? This is because some of them come under copyright protection. The law of copyright protects certain types of artistic works. And as you see, what is an artistic work? It is a very broad category for many different industries and types of works. And it largely deals with, for example, paintings, sculptures, drawings, or even photographs, where the work has a certain artistic quality. And under the laws of copyright, the design drawing of a design itself, for example, they may even be considered artistic works that are protected by copyright. So it is quite a complicated body of law, because you have designs that may be protected under designs, but at the same time, you may have certain drawings or you may have certain works that are protected under copyright instead. And The protection safeguards offered under copyright law are that it gives you the right to reproduce the work, to publish it, or to communicate it to the public. It is slightly different from having a registered design right. But you need to know that copyright is something that is not registrable under the laws of Singapore. It is something that is arrived at by default. So for example, if you are the writer of a book, you don't actually register it for copyright in Singapore. It is accrued naturally by virtue of you being the writer. So, you know, you may be wondering at this stage, your work is not at its final product or article, and you don't know if the work that you're working on right now, while it has artistic or aesthetic value, is it something that is registrable, or is it something that's unregistrable? In order to consider where your work or type of work comes from, you need to look at the interaction between various types of IP. And today we'll be focusing more on the interaction between design and copyright. Now, assuming that a design is registrable, it will not, as an unregistered design, enjoy any protection under both copyright law and the registered design law. If it's if it's registered under the Registered Designs Act, it will only enjoy protection under the Designs Act, but not copyright. So therefore, your work only enjoys copyright protection only if it's unregistrable under the Registered Designs Act. I know it's very complicated. So if your design is registered, look at the act at which you're being registered, the Registered Designs Act. If your design qualifies but is not registered, there is actually no protection at all. And if it's something that is artistic, it's not meant for industrial application, then your starting point should be copyright. However, do note that there are also key differences between what is a registrable design and what may be protected under copyright. For example, the visual expression of a designer's design may be protected as an artistic work under copyright law. But also do note that if you have something that you would imagine has copyright protection, if subsequently it's something that's mass produced, say 50 articles, or sorry, more than 50 articles, then it's not something that that qualifies for copyright protection. So as you can see, it can be troubled waters that you're swimming in, especially as you know, an emerging designer, and you don't know what kind of work your design qualifies under, and especially, you know, these kind of things are industry specific, because when it comes to designs and works, artistic works, it really depends on what kind of work you're doing. So you often ask yourself, where should I start? First, it is important to take a step back and consider again why IP is so important and how it can help you. IP is able to be used not just as a sword, but also as a shield, as you'll be able to see later. And here is just an example of how it can really be quite complicated. A simple, not a simple, but a single product, such as a car, can contain various types of IP. The advertising and promotional content can be copyrighted, for example, but at the same time, the car design could be a registered design. So, and there are other types of IP as well that are involved. So it is very complicated. And with that as a background, we can move on to consider one of the more preliminary issues that emerging designers should consider. We look at three types of relationships. First, the employer-employee relationship, where the design is created by an employee in the course of his employment. The employer is treated as the owner. Of course, this would be subject to any other agreement between the parties. And in the past, for commission works, where the design is created in pursuant of a commission, the commissioner is treated as the owner. But do note that the law has recently changed, so that currently the design vests in the designer by default. And it's only where a separate agreement is carved out from this. And that is where the designer gives up his rights to his design. And also do note that, sometimes the design has more than one author or more than one artist, and you could share ownership rights with your co-owner. Or for example, if you license out or you assign out your rights, you are not automatically the only person who is the sole exclusive owner. And moving on to, you know, using your IP as a sword, as emerging designers, you don't just you do it for your hobby, right? You need to make sure that it's your livelihood as well. You need to know how to exploit your IP, and oftentimes the question you should consider is whether or not to do a license or an assignment. Now, an assignment is in essence a transfer of ownership, while a license is in essence permission to do what um, what otherwise would be infringing your rights of a design, for example. So, um, licensing is something that's advantageous generally because it allows the owner to retain control over the use of your right. So, for example, if you own the design to something, you still have a majority of say over how to use that particular design, as compared to an assignment where you could just be assigning your rights to an organization, and you might not have the same say over how your design is to be used in future. And of course, such licensing gives permission to others in exchange for royalties, right? Benefits for yourself. And you need to know that um, managing your IP at the start, it doesn't just help you to go to that step. It's beyond that. It builds a good foundation for financing. It generates value through transactions with others. And by having strategic partnerships subsequently, you use your IP as a tool for collaboration or even a recognition for yourself. Now we look at some of the things everyone can undertake, armed with the information that we already have, right? First, you need to know what your work involves. What is the legal definition that applies to your work? For example, copyright, or is a registrable design more relevant? And on top of understanding your rights, you need to understand what rights there are of others so that you don't want to infringe others' rights, correct? And you need to understand the relationships that you have with other people, be it a commissioner or someone that is co-writing it for you. And most importantly, you need to know to conduct an IP audit. And what I mean by IP audit is it is important to consider how at every stage of doing your work, how you can manage your IP, note what is to be done so that as you lay the bricks of success for yourself, you know what to do at every stage. Now, there are some recent updates in the law. I'll just touch on them very briefly due to constraints of time. The registrable scope of designs has recently been expanded to include non-physical products, or even those that have these colors as design features. And when you register a design, do note that now the IPOS examination standards, to check whether or not your design is new or something that's capable of registration, is stricter, but certainly it is more, it provides more certainty. Also, I believe today is the release date of the PS5. Everyone knows that innovation for the future is not just about tangible property, but it's all about intangible property, where you have AR, VR, a design can be applied to not just a physical product, but also a non-physical product. And this includes graphic user interfaces as well. The recent changes in the law has accepted GUIs and how they may apply to an article, for example, on a mobile phone, such as an app, or even something that is non-physical. For example, you could have a design of a virtual keyboard, that is either in space or projected on a table. So, as you can see, it's the changes in the law really reflect how um, the government and both internationally and in Singapore is trying to use um, designs as a a key framework to boost creativity and innovation. Now, some key takeaways. Having said all that earlier, it's very complicated. The legal framework to the artistic work or design can be very, very complicated, especially to artists, right? And it's very subjective as well, because depending on what kind of work you do, you could be in the architecture business, you could be in the graphic design business, you could be in the gaming business. Um, all these rules and regulations apply quite differently to you. But the most important thing to note is that like many types of IP, designs drive value, and they boost the value of businesses as well as the economy. And as I mentioned earlier, that IP is important in terms of the initial stage for you to do an IP audit of your own profile. You need to know that IP in general is very important at every single stage, either as an individual wanting to expand your reach, or whether as a small company or even a large company, using IP to boost the growth, to lay the future steps for success. Now, as an individual, or perhaps as a small company, you may be wondering, okay, what steps do I take from here? What do you mean by an IP audit, or perhaps whether or not I should register something of mine, or whether it's not worth registering, for example. I think if we take a step back here, you need to perhaps, when conducting your IP audit, you may want to seek the help of organizations that are out there, that that can offer assistance to you. For example, the Intellectual Property Office of Singapore, IPOS, they do have their ways of consulting with individuals or even small firms to help you understand what is your IP and what you can do for your IP. And even organizations such as Design Singapore themselves, or say license collecting organizations, or artist representation organizations, they offer help readily as well to individuals, especially if you don't know what to do. And also, if you need help for professional assistance or legal assistance, there is an abundance of law firms out there, or even IP firms or media firms out there, that could provide some consultation as to what you can do, what you should do, or what you should not do. They are readily available, and you can just approach someone out there. For example, our firm, Ella Cheong, we are one of the legal services firm that advise on intellectual property. And as you can see, as a firm that is IP boutique law firm, what we do is we advise our clients at every stage of their process, or of their business. So, for example, if you're an individual who you might not know what is your end product or what's your end goal, you could even do an IP audit at that stage. Or, for example, you are now at a stage where other people are actually infringing on, say, your design. At every stage, from start to end, we do advise on IP for our clients. And of course, being a full service law firm, we also advise on different legal matters, from contentious and non-contentious, even to commercial matters. So, for example, if yourself or your company is already established, and you want to have consultation on franchising, we do that as well. And of course, we do have services for corporate as well as personal legal services. Now, thank you so much for tuning in to my presentation today. I hope that you enjoyed today's presentation, and I hope that you have found out more about the intersection between design and what it is to be a registrable design under the law in Singapore. and as well as copyright. We do have a mailing list there, and we do generate a lot of material that is very interesting as well. So if you are very interested in that, please feel free. Our QR code is up on the screen now. Do register, and as always, if you have any questions on the presentation, do feel free to drop me an email or give me a call. A lot of the information is condensed, and it's very difficult to explain over 30 minutes of a presentation. But if you have any questions, I will be very happy to share more, and please feel free to reach out.